Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is Thursday the 16th. We are here to have a small hearing on a procedural matter on the KPK docket. That's docket number 2011-00261. We will start with a roll call of commissioners.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett. Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Okay. And before we get started, we'll make sure that we've got, well, I see Mr. Jacobs. I see Mr. Mueller. Good afternoon, gentlemen. We're waiting on Ms. Stafford, I believe. I see Ms. Rosenberg, or at least she's got a screen up.
Yeah, I believe Ms. Stafford is, oh, there she is. She needed to be elevated.
Okay, we got Mr. Farron, we got Ms. Stafford, we got Ms. Rosenberg. It looks like we have a full house. We have before us the pattern of violations final pre-hearing order. That final pre-hearing order identified that today we will undertake oral argument on the second issue from section 1 of this order, which issue is what may the commission consider when determining whether staff proved KPK committed a pattern of violations. It looks like each side has up to 15 minutes exclusive of commissioner questions to present argument. Before we move to that argument, I have a procedural matter, and then I will see if the attorneys have any procedural matters before we get started. But the procedural matter I have is that we recently received into the record attempted public comment from 3 commenters, the Colorado Petroleum Association, the Small Operator Society, and CAMRO, which is a entity that represents mineral interest owners. I never can remember the actual acronym. Pursuant to discussion that we had with the parties on August 18th that was led by Attorney Jacobs on behalf of KPK, we entered a standing order that we would not allow public comment into the record, and instead we would focus the record on presentation from the parties in this matter. So we have stricken the public comment that was recently received, and we will not be receiving public comment into the record on this matter. Mr. Jacobs, I assume that since you started this by demanding that we not have public comment, that you're comfortable with this position. Ms. Stafford, I'm hopeful you're comfortable with this position as well. It's not a position that we're going to negotiate. I'm just stating it for the record.
Happy to respond. I'm not comfortable with it, and I think my concerns raised on August 18th have not been exactly properly characterized. I raised concerns about facts remaining in dispute and the effect of taking public comment on this commission's deliberations prior to establishing what facts are found and what facts are not found. I believe that the comment you're proposing to strike is not factual in nature. It has to do with what you may consider, how your rules are to be interpreted, how the statute is to be applied in your work. You get comment like that all the time. Senate Bill 181 is commonly referred to in public comment and why it requires you to do certain things. And I don't see much difference there. I didn't ask that you strike comment or discontinue comment. I simply raised my concern since I didn't know who would comment, what they would comment about, and I would have no right of cross-examination. You decided how to handle that concern, not in any order that I've seen or been privy to. I understand that at the beginning of public comment, you said you would not be taking public comment, and that was no doubt in response to the concern I raised, but I did not specifically request that you discontinue the receipt of public comment. I simply raised the concern about its effect, unknown effect, on your ability to operate as fact finders in coming to a conclusion at the end of this hearing, and how that affected my client's interests. So I do wish to clarify that, Mr. Chairman. Thank you.
Thank you for the clarification, Mr. Jacobs. At this point, unless my commissioners disagree, we will indeed strike all public comment, whether it's coming from folks from one side or folks from the other, and we will focus our attention on the presentations from the parties, the evidence and witnesses from the parties.
May I ask one last, I'm sorry, please continue. I just had a related question, procedural. Is that on the commission's own motion that you're doing this?
Yes, we've not been asked to do this, only by either side.
Thank you.
Do you have anything further procedural before we get started?
Mr.
I
Chairman.
believe my colleague, Mr. Mueller, has something. Go ahead, Kirk.
Thank you, John. Mr. Chairman, we do have one item to present to the commission that we previously presented to Hearing Officer Peskin. It has to do with the order of presentation at next week's hearings. Let me share my screen. It's in the final pre-hearing order from Hearing Officer Peskin. Hopefully you can see that.
Actually, I cannot at least see it, Mr. Mueller.
Here we go.
Okay, thanks.
Okay, yep, I can see that.
This is out of Hearing Officer Peskin's order. It's the order of presentation. You will see that he has bifurcated basically our bifurcated hearing on pattern of violation into the case presentation for a pattern violation, and then separately presentation on ability to pay with deliberation in the middle. That didn't make sense to us, and frankly, we discussed it with staff. It didn't seem like a good approach by staff either. So we both went to Hearing Officer Peskin and said, you know, we think we ought not to do it this way. We ought to move B down to C. There should be one final deliberation. The presentation of both pattern of violation as well as ability to pay can happen sort of uninterrupted, you know, in one process. And Hearing Officer Peskin declined to do that. And he explained his position by saying, well, you know, I know it's absurd, but what if the commission decides they're only going to impose a fine of $100? Then we wouldn't need to have a presentation on ability to pay at all. In all candor, we don't think that's going to happen. We already know that you have proposed fines that are $1.6 million. You already know that we have an ability to pay, according to our accountants, that is about $800,000. So it seems to me there's no risk that we're going to come in at a number that's so small we aren't going to need the presentation on ability to pay. We think it would be smoother. It would do away with 2 openings and 2 closings. And frankly, it would just be more streamlined not to have deliberations in the middle and then deliberations at the end. And so I would propose, although the hearing officer declined to do it, that you do that on your own initiative. I think it'll make for a smoother process next week.
Ms. Stafford, would you like to comment on that?
Thank you, Chair Robbins. At this point, staff does not take a position on KPK's renewed request here. So we will leave it up to the commission's discretion how they feel is most appropriate to proceed here.
Okay. I think I'm comfortable with that approach, Mr. Mueller. I think that hearing on all the issues would then allow the deliberation to take place at one time. Does any commissioner have any real heartburn about unbifurcating the bifurcated trial that we've established from Hearing Officer Peskin? All right, seeing none, we will amend the case final pre-hearing order so that it will now be order of case presentation on pattern of violations, followed by inability to pay, and then commissioner deliberations on penalty and corrective actions, etc. Thank you for raising that, Mr. Mueller. Appreciate it. Anything further from staff or from Ms. Stafford?
I did have one issue now that we're looking at the final pre-hearing order, which I have not yet run by Mr. Jacobs, but I would imagine he might be appreciative of additional time as well. Currently tomorrow, we are due to submit a jointly prepared spreadsheet containing all exhibits by noon, and I am wondering if we could potentially have until close of business in order to accomplish that, just to ensure we have enough time following this hearing. It seems like a bit of a quick turnaround to require it to be submitted by noon.
Fine with me. Mr. Jacobs?
I concur. The additional time would be appreciated.
Okay.
And I do have one last procedural matter.
Go ahead, Mr. Jacobs.
There are a number of additional witnesses listed for the hearing on Monday, and I didn't know if you would entertain swearing them in individually or at the beginning of the hearing, and it dictates who's available when. Do they need to be ready at 9:30 for a joint swearing in, or will we just swear them in at the time of their testimony?
We can just swear them in at the time of their testimony. That way we're not taking up people's time at the beginning of the meeting. And it's pretty quick. So at the last hearing, everybody just happened to be in the room. So it made sense to go ahead and do it all in one fell swoop.
Thank you very much, Mr. Chairman. That was the only other procedural matter that I had.
Okay. So again, with those procedural matters taken care of, we now will move to oral argument on the singular issue, what may the commission consider when determining whether staff proved KPK committed a pattern of violations. I believe that we have staff going first. Is that right, AAG Davenport? Is that right, staff?
I am under the impression it's right. It appears Mr. Davenport is not with us. Oh, no, there he is.
Okay.
I don't believe, and I can be corrected if I'm wrong, certainly that the final pre-hearing order did set forth whether it was staff or KPK going first in this particular hearing. However, I do think it's appropriate for staff to go first, given that they have the burden.
Yeah, and I was reading off of Roman numeral 4, in which staff has the burden, therefore will present its argument first. I know that was as to the hearing Monday, but let's go to that route this morning. Ms. Larson, I believe that you will be our official timekeeper.
That's correct.
Okay, great. And Ms. Stafford, the floor is yours for up to 15 minutes exclusive of questions from commissioners.
Thank you, Chair Robbins. Good afternoon, Commissioners. I'm Caitlin Stafford, Assistant Attorney General on behalf of staff. We are here today to discuss the issue of what the Commission may consider when determining a pattern of violations. And this is a situation that requires the Commission to interpret Rule 525(d)(3). First, the text of the rule is clear, and the plain language supports staff's interpretation. And second, even if the Commission finds the rule ambiguous, staff's interpretation is reasonable when read in the context of Senate Bill 19-181, which preceded the adoption of the current rule as it exists today. First, I'll turn to the issue of the regulatory interpretation. The text of 525(d)(3) unambiguously supports staff's interpretation, and the Commission need look no further than the plain text. Under Chase v. COGCC, when interpreting a regulation, we should apply the same basic rules of construction as one would to interpret a statute. Quote, look first to the language of the rule and analyze the words and phrases according to their plain and ordinary meaning. In line with the 100 series rules, COGCC series rules, where on the last page of the rules direct that all words not otherwise defined but used in the COGCC rules should be given their usual and customary accepted meaning. If a regulation is unambiguous, then canons of construction need not be applied. In their brief, KPK launches directly into an analysis of the history of Rule 525. But again, such analysis is only necessary if the regulation is truly ambiguous. Here, it is not. And just because KPK offers a different interpretation of the rule does not mean the language is actually ambiguous. Here, in construing the rule according to its plain language, it is clear that there are two elements in the rule the Commission may consider when determining a pattern of violation. Looking directly at Rule 525D3, I start with the first sentence. The first sentence contains two elements the Commission will consider in their determination of pattern of violation: an operator's history of violations and any other factors relevant to the objective determination here. The purpose of the first sentence is to identify what the Commission, hearing officer, or administrative law judge will look to in order to consider pattern of violation. By leaving that catch-all, quote, any other factors relevant in, it's clear from the rule that relevant factors might vary in each case and may not only be limited to an operator's history of violations. Second, in the second sentence of the rule can only be read to modify what the Commission considers in that first element of the first sentence, the operator's history of violations. That is, what is meant by the term history of violations. And the second sentence explains that only Commission orders, that is, orders finding violation or administrative orders by consent, speak to the history. The second factor in the first sentence needs no explanation. It serves its purpose as a catch-all to reference other relevant factors. This Commission should reject KPK's interpretation because it would impermissibly delete words from the regulation. To support their reading, KPK invokes the canon of statutory construction, cautioning against superfluity. However, KPK contorts the surplusage canon to fit its interpretive needs. The surplusage canon actually counsels that every word and every provision should be given effect, and that none should be ignored. What KPK asks the Commission to do is to ignore the, quote, other factors relevant language. Note again that these canons are only interpretive tools, and words and phrases should be interpreted according to their plain and ordinary meaning. Now, even if the Commission considers the rule text to be ambiguous and moves to analyzing the rule's history and purpose, staff's interpretation is reasonable here and the Commission should accept it. Only if ambiguity in the construction and interpretation of a rule, only if there is ambiguity in the construction or interpretation of a rule, should the Commission consider employing other tools of statutory construction or regulatory construction, which includes the history and purpose. And the history and purpose is typically found in a statement of basis and purpose for a particular regulation. The 2014 final SBP again states what the Commission may consider when determining what is meant by, quote, a history of violations. Like the rule, it points to violations confirmed by Commission order. However, a full analysis of the history and purpose of the rule as it exists today must also incorporate an analysis of Senate Bill 19-181 and the 2020 mission change rulemaking. Now, the rule was passed in 2014 and was previously Rule 523, and that history is useful to an extent. But Senate Bill 19-181 was adopted, as we know, in April 2019. And then Rule 525 was readopted in 2020 through this lens of mission change. We cannot ignore this part of the statutory and regulatory history. Now, as the Schlapp case counsels, which is at 284 P3D 177, a regulation must be interpreted to as not conflict with the object of the statute it implements. We must acknowledge statutory changes of Senate Bill 19-181, changing the mission of the agency to regulate oil and gas operations in a manner protective of and minimizing impacts to public health, safety, welfare, the environment, and wildlife resources. And this necessitated updates to the rules. Now, the agency's focus has changed to regulating in a manner protective of public health, safety, welfare, the environment, and wildlife resources. And in order to effectively regulate, the agency must have a full and complete understanding of the scope of oil and gas operations by each operator. Determination of a pattern of violation is part of effective regulation. And with respect to pattern of violations, understanding an operator's history of violations, informative of that pattern, does not mean that a consideration of other relevant factors is somehow foreclosed from the overall decision-making process. It is this commission's duty under Senate Bill 19-181 to consider other relevant factors, including an ongoing pattern of noncompliance, outstanding spills, and other commission orders speaking to an operator's failure to operate in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Exemplified in this case with the Rule 901A order. It is within this context that staff's interpretation of the text of the rule is reasonable. Now, if the commission disagrees with staff's interpretation of Rule 525D3, it may still consider other factors relevant to KPK's operations during this phase of the hearing. First, the rules allow for the commission to take administrative notice of certain information during the course of any hearing pursuant to Rule 517C. The list in Rule 517C includes other governmental agencies' orders, court decisions and orders, and, quote, commission and commission staff reports, data, files, documents, and records, end quote, as well as matters within the expertise of the commission or commission staff. The materials that staff is asking the commission to consider fit this description, and all the information and data housed in some way is in the COGCC database. This includes inspection reports, spill reports, plans, and progress on remediation work plans, the 901A order, and other information, other relevant information. And second, the door has been open to a review of the full scope of KPK's operations during this phase of the hearing. KPK has put both their operating history and current operations, their conduct, both past and present, at issue during this pattern of violation phase of the hearing by their continued reference to their, quote, responsible operations, which they point to again in their initial brief. But this characterization is inaccurate based on the public information available through COGCC. We have inspections with outstanding corrective actions that go unaddressed for extended periods of time, remediation work plans with a litany of conditions of approval, and the issuance of the 901A order requiring KPK to take immediate action to avoid, minimize, and mitigate impacts to public health, safety, welfare, the environment, and wildlife resources, to remind you of a few. This is not the kind of conduct indicative of, quote, responsible operations. And KPK's overall conduct is directly at issue in this phase of the hearing. To allow KPK to make these assertions about their history of responsible operations without allowing staff to present evidence and rebuttal during this phase of the pattern of violation hearing is both unfair to staff and risks prejudicing this proceeding. In conclusion, staff asks that you find that the text of the rule is clear and that the plain language supports staff's interpretation, and that you allow staff to introduce the evidence pertaining to, quote, other relevant factors that they have presented thus far. Thank you.
Thank you, Ms. Stafford. Mr. Jacobs or Mr. Mueller, I'm not sure which of you or whom of you will be presenting, but I believe you are now up.
Mr. Mueller's got the lead on this.
Thank you, Mr. Chairman. Let me start where Ms. Stafford ended. Let's talk about the open door for a moment. It is very much the case that we have pointed to our good record and evidence of good faith in trying to comply because we are facing an allegation that you can consider everything under the sun. And if you are going to do that, then yes, indeed, I think we can refer to the good things under the sun as well as the bad. We are quite content to read the rule the way it should be read and apply it the way it should be applied, and limit reference and consideration by this commission of our good deeds to those that are at issue in the current NOAVs or that were at issue in the prior NOAVs, which is the proper subject for this commission when you go to decide if there's a pattern of violations. So the door is only open because staff is trying to bring in materials that we don't think belong there. We're happy for both sides to play by the rules and not refer to things beyond the orbit of the current NOAVs and again, past adjudicated notices of violation. But having stopped there, started there because I didn't want to forget the thought, let me go back to the top and talk a little bit about the plain language of the rule. The notion that this two-sentence rule creates a distinction, a deliberate distinction between a pattern of violation and a history of violation is an artful argument, but not one that can bear any weight. There is no such thing as a pattern of violation independent of a history of violation. The question is, do the histories of violation demonstrate a pattern? You can't talk about one as though it is different from the other. They are coterminous. They are the same thing. I want to share my screen and show you an excerpt from a brief from staff. Are you seeing my screen yet?
That's your
Yeah, that's
desktop.
what we're seeing, but it's not.
Got it.
It's your desktop, I believe.
If you could pause our time, Mr. Chairman.
It's been paused.
Thank you.
Let me see if I can do this. Okay, now, yeah. That's it real quick. Sharing the sorry, how do I zoom? Sorry, no, it's hopefully what you see now is a page of a brief written by staff. And can somebody confirm that for me?
Yes, we can see a staff, the legal elements constituting a pattern of violations is in the middle of the page.
Thank you, and thank you for your patience with me. I want you to read this sentence. A pattern of violations is a history of non-compliance with the Act, Commission rules, orders, or permits. This is staff itself defining what a pattern of violation is. It's a history of non-compliance. This notion that you can tease apart pattern of violation and history of violation, that the drafters of this rule somehow intended to say, all right, when it comes to history of violations, you're constrained to adjudicated violations. In all fairness, we're here to see if there's a pattern of violations, not a pattern of field reports, not a pattern of alleged violations. If you want to know if there is a pattern of violations, you're constrained to look at adjudicated violations. They wouldn't say that on the one hand and then turn around and say, on the other hand, when you're looking for a pattern, you can look at anything. It's an artificial construct. It was never intended that these two concepts could be different. They are not different. Again, you can't have a pattern without having a history, and you can't know if there's a pattern without examining the history. And when you examine the history, the drafters couldn't have been more clear. You are constrained to adjudicated violations, not other things. Now, this staffer makes the good point that if you are too harsh in reading the rule as I've just described, then you lose that language that talks about any other relevant factors. But that's not necessary. You can, within the construct of, for example, the 8 NOAVs at issue in this case, the past NOAVs, look into the record of those NOAVs, look into the testimony that we had for days and days from representatives of both staff and KPK, describing how the parties responded, describing mitigating and aggravating circumstances, each of them. Those are the kind of other factors that aren't captured necessarily in a adjudicated violation, but that are relevant to the violation and are relevant to the operator's behavior and relevant to whether or not there's a pattern. So you don't lose that language of any other factors. You do, if you go with staff's construction, you do lose the second sentence of 525D3, because there will never be a situation where staff can't backdoor using the any other factors and do just what they're doing here. 1,300 records in COGCC, something like that, a 901A order that's been issued but not adjudicated, all manner of things that couldn't be farther from an actual violation. And they're saying this is all evidence of a pattern and a history of behavior that you can consider because of those words, other factors. You will read out of the statute the second sentence if you go down that road. And you know from the briefing and you know from Ms. Caitlin's remarks that there is a prohibition against construing statutes that way and contracts and any ambiguous document or confusing document or any document, frankly, where the parties may disagree. Courts have a tool belt for trying to sort through that. And one of the first tools is to say, we need to try to resolve this in a way that gives meaning to all the language. And violence is done if you follow staff's directive. There will never be a situation. I challenge staff to identify one in which they will ever be constrained to just considering adjudicated violations. Now, courts have other tools in their tool belt too when there are questions about what a statute or a contract means. Among them are to look at the course of performance of people who are subject to the contract or the rule or the regulation. And here we have a course of performance by staff and by the commission that would tell a court, this is how they understood this rule to operate and how they understood it to be administered. Staff itself has guidance in which it directed that non-adjudicated warning letters and inspection reports should not serve as a basis to assert a pattern of violations. That's staff guidance and penalty guidance. This commission has had few, but some prior hearings on notices of, patterns of violation. And in virtually all of those, the examination was constrained to just adjudicated violations. The typical order finding a pattern of violations had boilerplate language that said that the commission was taking into account violations currently at issue, as well as those confirmed by prior orders, and finds that the operator has engaged in a pattern of violations. That's how you have done it. That's how staff has advised that it ought to be done. And that's the only way you can do it and still honor the language of the rule. It's evident that that was an important consideration for rulemakers. It's a standalone sentence. And it's not surprising that you see something like that in this rule. You know, we live in a country where it's baked into our republic that you have a right to confront your accusers. You have a right to due process. You have a right to be heard. And just because somebody says something or accuses you of something doesn't mean they get the last word, doesn't mean you don't have a chance to come forward. Staff has a footnote in their reply. It's footnote 2. It says as follows: staff asserts that all of its reports are free from bias. All of its reports are free from bias. So you really don't have to look any further than look at their reports. You don't have to, I could just as well tell you, I suppose, that everything KPK says is free from bias. But this is an adversarial proceeding. This is KPK's opportunity to tell its side of the story and to be heard. And what staff is basically saying is, we're bias-free. Just look at the field inspections and whatever else is to be found in COGCC, and that's all you need to know. You don't have to sorry, I turned myself off. You don't have to look any farther than that. You know, that simply can't be reconciled with the language of the statute. We're not here to see if there's a pattern of inspection reports or a pattern of alleged violations. You can't prove violations by proving a pattern of alleged violations, any more than you can say somebody is guilty because they've been charged with lots of other stuff too. Staff has cited Rule 517, the administrative notice rule, which is the counterpart to the judicial notice rule when you're in front of trial court. And it basically allows that you can, commissions, for example, courts can take note and without demanding proof of obvious propositions. Christmas in 2020 fell on a Friday. You can take judicial notice of that. You can take administrative notice of that. You can take notice that there are a whole bunch of documents in COGCC. You can take notice that the director has issued a 901A order. You can't take the next step and say, therefore, the substance of those things of which we take notice is true, and we don't have to hear from the other side. It is true because we're told that they operate without bias. That's not adequate. That's not what that rule is meant to do, and you can't employ it that way. Frankly, I don't think you're going to. You do, however, have to either give KPK the opportunity to respond to, for example, the NOAVs that have been noticed but not adjudicated. You need to give them the chance to respond to that before you take that into account as a pattern of violations. They're not violations yet. Those documents in COGCC are not violations. The 901A order is not a violation. And you can't, as staff has suggested in its footnote, you can't walk away and say, well, you know, the fact that Director Murphy issued a 901A order just shows that KPK is a bad actor because, you know, she wouldn't have had to issue the order otherwise. That's what they're trying to do, and you can't reconcile that with due process. The second sentence of 525T3 is due process, and you can't set that aside.
Does that conclude your argument, Mr. Mueller?
It does.
Okay, very good. Ms. Stafford, or Ms. Larson, does Ms. Stafford have any additional time remaining?
Yes, she does. She has 5 minutes and 14 seconds, if I'm not mistaken. And
go ahead, Ms. Larson.
Oh, I was just going to let Mr. Mueller know he used 10 minutes and 29 seconds. So he has 4 minutes and 31 seconds remaining.
Okay. Ms. Stafford, given that you bear the burden here, do you desire to use any of that time for any rebuttal, knowing that we will have an opportunity for questions?
Thank you, Chair Robbins. I guess just briefly, if I may, take a few minutes of my time.
Go ahead.
Throughout Mr. Mueller's argument here, he's speaking to KPK's course of performance, other relevant information, the history as it relates to the history of violations, all the things that could potentially be brought in here in the consideration of whether KPK has committed a pattern of violations. And I think the way that he has phrased some of this argument about a history of noncompliance, a history of things of that nature, further gets to staff's point here that additional relevant information should be allowed in this course of this hearing, and the commission can decide the weight that they will give to those particular documents and that particular information. It does not mean they should be completely disallowed for purposes of the hearing next week. It means the commission should consider all of the information that is available to it, which includes the information in COGCC. And staff would request that you allow us to introduce such information next week. And thank you.
Thank you, Ms. Stafford. Commissioners, do you have questions for counsel of record at this time?
Mr. Chairman, I don't know if I get any of my remaining time as a rebuttal. If I do, I'd like to use a moment or so.
All right, you have a moment.
The notion of weight is, well, all right, you should hear it, but maybe you give it less weight. That's inconsistent with staff's position. Either this stuff is admissible or it's not. And balanced against, whether or not something is admissible, it's a test between whether it's probative versus whether it's prejudicial. And for unaddressed, unadjudicated allegations to be admitted in for the commission to consider, but they may say, well, we're going to consider it, but we're not going to give it too much weight because we recognize it's just an allegation. It's a slippery slope. You can't do that. You can't do that in courts of law, where the rules of evidence or the rules of the substantive law that's being enforced, where materials aren't relevant, they don't come in because it runs the risk of prejudice. And you can't open the door and say, well, all right, the stuff all comes in, but we'll discount it a little bit. It goes to the weight, but not the admissibility. We did that with hearsay. Hearsay does allow for some of the discretion like that. This rule does not.
Right, thank you. I think that was a little more than a moment, but it was a question I was going to ask you anyway, so that's fine. I guess I'd ask either, or actually I'll turn to my fellow commissioners. Questions for these guys? Commissioner McGowan?
Thank you, Mr. Chair. And my questions right now are for Mr. Mueller. So I'm wondering, I just want to clarify if I'm following your definition of what can be considered and what cannot, and only current adjudicated violations can be included in considering pattern violations. I assume that we would also then be able to consider all the inspection reports therein of those notice of violations or those official findings of violations. So any field reports, inspectors' reports, under which there might be multiple inspections where the same violation has been observed would be considered then, would be, I don't know if eligible is the right word I'm looking for, but would be, we'd be able to consider those.
Yes, I think absolutely you would. That is part of, to the extent it's part of the record here. And yes, that's a good example of another factor. Okay, thank you. And then I'm curious to know if what we're talking about here is something that may or may not yet have happened. So if there's an outstanding violation, but it hasn't been adjudicated by the commissioner, or it hasn't been decided by the director, then we should not consider those. 901A for me is a little bit of a different animal in that it has actually occurred. It has been implemented. It is not something that may or may not occur. And so I'm wondering if you could explain the distinction or why that would be different and should not be considered, because it's something that has indeed occurred and the director has taken action. Well, it is neither a OFV nor an AOC that has been entered by this commission. It is a director's unilateral order with which KPK is complying for various reasons, but it is not an adjudicated proceeding. It is not an adjudicated violation. It's not. So in your mind, that wouldn't even be another factor? Agreed, it would not be another factor. What you said before would be the inspection reports relevant to the current NOAVs, ditto past NOAVs.
If I could add an answer to your question, Commissioner McGowan, just briefly. It's also based on reasonable cause, just like an NOAV, and it's not been appealed. There is a process for appealing and reviewing and this commission affirming a 901A order, and that has not occurred. So it is not.
Would you like to answer that question as well from your perspective?
I would like to add something there. This order the 901A order has not been appealed because KPK has not initiated a proceeding to appeal it. It is an order issued by the director that is in effect right now. There are no proceedings to appeal it currently at this time, and it should be considered as part of this proceeding.
Ms. Stafford or Mr. Mueller, has the appeal time run? Or has the appeal time initiated on the order? Ms. Stafford first.
Thank you, Chair Robbins. At this time, the way that I have understood the rule, there is no, or at least, if you could give me a moment to confer with counsel, I think I might be reading the wrong section here.
That's fine.
Mr. Chairman, I'm happy to respond on KPK's behalf because as the recipient of
Actually,
the first...
hold on, Mr. Jacobs. I want Ms. Stafford to hear your response. So let's let her get her ducks in a row and then we'll give you an opportunity.
Thank you.
Okay,
Thank you, Chair Robbins.
Ready?
Yes, sorry. It's my understanding there's not a specific time frame set for initiating an appeal. However, I would note that this order was issued on April 12th and it is now September 16th. And KPK has done nothing to initiate an appeal of this order.
Okay, now, Mr. Jacobs, if you could please briefly respond.
Certainly. Thank you, Mr. Chairman. Yes, as the recipient of the first ever 901A order, we've done a little bit of research on it. And if we do appeal it and had appealed it earlier in April or May, we weren't even counsel in this matter until late April. It would have been up for determination at the very next commission hearing, regular meeting of the commission. We chose not to appeal it at that time, especially as new counsel, and we reserved our right, as I think we're permitted, to appeal it or the failure to lift the order if we make reasonable progress. And we've submitted summaries of progress to the director, hoping to have the order lifted or relaxed over the intervening months that Ms. Stafford just reminded us of, April to September. So no, there is no deadline beyond which we've gone to appeal the order. We can appeal it at any time and we'll do so when appropriate, and you'll hear it at your next meeting.
Okay, thank you for that. Further questions from commissioners? Commissioner Gonzalez.
Thank you, Mr. Chair. I've got a question about the 11 outstanding NOAVs that staff has cited in their briefs, and my understanding they want to bring forward in the hearing next week. You know, these NOAVs are, you know, they're allegations that have to be proven beyond a preponderance of the evidence. There's a burden of proof there. And I'm curious that why should allegations where a burden of proof has not been met or any associated testimony or evidence considered with those allegations, why should that be considered as part of a pattern of violations determination?
Ms. Stafford.
Thank you, Commissioner Gonzalez. You know, staff does not issue NOAVs without reasonable cause, as I believe my opposing counsel has also pointed out during their argument. Staff feels it is appropriate to consider these NOAVs here to the extent that they speak to a pattern of noncompliance, a pattern of a history of noncompliance, which is what this rule around pattern of violations is trying to get at. So in that sense, we feel it is appropriate for the commission to at least acknowledge that these exist. Thank you.
I mean, I think we can acknowledge that the allegations exist, but I think that there's an importance for that burden element there, right? You know, we don't just make rulings based on allegations, we make them based on a hearing and appropriate consideration of all sides. So in that regard, you know, I think that burden of proof is pretty illustrative of the necessity for due process associated with these allegations. And so I'm trying to understand, is there anything we're going to learn from these allegations? I think that we can all acknowledge that these these NOAVs exist and that there are allegations out there, but until a burden of proof has been met, what is that probative of?
Thank you, Commissioner Gonzalez. Oh, I'm sorry, Chair Robbins.
Yeah, go ahead.
Thank you. You know, that's all that staff really wants here is the acknowledgement that these NOAVs exist. You as commissioners can decide the weight that you apply to them. We want you to take into account the full picture, the full scale of KPK's non-compliance issues with this commission. And that's all we're really asking for here.
And I'll turn this to Mr. Mueller. Does KPK have any problem with us acknowledging the existence of 11 outstanding NOAVs?
Yeah, only this, it's not relevant because the question here is there a pattern of violations, and alleged violations are not a pattern of violations. The fact that you're accused of something doesn't mean you're guilty of it. So can you take it into account and say, yeah, there's a 9018 order out there, and then not pay any more attention to it? Yeah, that's the B answer. The A answer would be it's not relevant. First of all, it's not allowed under the second sentence of the rule. But can you acknowledge, I mean, you can also acknowledge that Christmas last year fell on a Friday, but it has nothing to do with these proceedings. And quite frankly, it tends to taint these proceedings.
Thank you, Ms. Mueller. Thank you, Ms. Stafford.
Further questions? All right, I'm not seeing further questions. Thank you, counsel, for the argument. Why don't we take a 8-minute break and reconvene in 8 minutes, and it'll give a chance for commissioners to get their thoughts together. Does that work for everybody? Okay, we'll reconvene at the top of the hour. Okay, I see our 5 commissioners. We've all made it back. A chance to collect our thoughts. For the attorneys, unless we ask you a specific question, you're done at this point. Thank you very much for your time. We'll keep you on the panel in case a question arises. At this time, commissioners, I believe we're due for a little deliberation on this singular issue of what evidence can be allowed in on the pattern of violation, as was argued to us. Anybody have initial thoughts? Bill, Commissioner Gonzalez.
Sure, thanks, Chair. You know, there's a couple things going on here that we're thinking about, and just in terms of what we're considering for this current pattern of violations issue and hearing. I think it's important. I've kind of boiled it down to 2 things that are important for me. One is the consideration of NOAVs, notice of alleged violations, that staff has daylighted in their brief. There's 11 of them, as well as the orders for which staff has entered into at least discussions of in their briefs that KPK is somehow alleged to be in violation of, that are outside of those NOAVs. And so I'll kind of take those 2 in those separate parts. As the 11 outstanding NOAVs and the associated allegations for those NOAVs, the reports associated with them, as well as any other evidence associated with them, I don't believe that these should be considered as part of the pattern of violations hearing. In my reading of Rule 525D, I believe that the language of the rule makes clear that the pattern of violations considerations should be limited to violations confirmed by a commission order through an AOC, an administrative order by consent, or an order finding violation, and not to unadjudicated matters. It's clearly written. It's the last sentence of that rule, and I think it's an important one. And I believe that final sentence creates that limitation on interpreting the remainder of the rule. When I think about the other factors and the other relevant factors, I think that those are other relevant factors associated with the violations that are at issue for the pattern of violations and that are surrounding the particular orders finding violation and administrative orders by consent that have been adjudicated. There's also similar language in the enforcement guidance and penalty policy, which states that the director will only consider orders finding violations or administrative orders by consent and not unadjudicated warning letters and or inspection reports as a basis to assert a pattern of violations. That makes me question as to whether or not even the assertion of those elements within the briefs is appropriate for this pattern of violations. Now, I don't think that the pattern of violations assertion that we have before us is necessarily tainted by that, because there's plenty of violations that we as a commission have found in our hearing of the matters before us a couple weeks ago, to move forward with at least consideration of a patterns of violations hearing and determination. I think that an interpretation that contemplates the consideration of alleged violations would be unfair to the party that is subject to those allegations, and to base a finding of pattern of violations and assess associated penalties or other remedies on mere allegations that have not had the opportunity to be adjudicated before this commission would be unfair and not consistent with the rule language. I think Mr. Mueller said this, and I tend to agree, that I think the rule addresses patterns of violation, not patterns of allegation. And I think that's important here. For any orders for which no notice of alleged violation have been brought, and for which staff wishes to assert as violations to be considered as a pattern of violations, I likewise believe that such should not be considered as part of this pattern of violations hearing. If there's a violation of a rule, there's a process for enforcing that rule, adjudicating that violation, and it starts with the NOAV, and it ends in either an AOC, an order finding violation by this commission, or a dismissal if we don't find the violation. I think that process is important. It should be followed to ensure due process. And I think for any rule, order, or permit violation that is alleged to have been violated, I believe that staff should promptly issue an NOAV if staff wishes to commence enforcement on that alleged violation. And I think addressing those allegations or even unalleged violations to a rule here as part of a pattern of violations is inappropriate. And so for those reasons, I think that what we should consider as a part of this pattern of violations hearing should be limited to those matters that have reached adjudication, resulting in an order finding a violation or an administrative order by consent, along with all facts, evidence, and other relevant factors supporting those matters. That's kind of where I've landed based on what I've read in the briefs, the responses to the briefs, the evidence in those briefs, and what I've heard in the presentation by council today.
Thank you, Commissioner Gonzalez, for providing your thoughts and perspective and your analysis. Others? Commissioner McGowan.
Thank you, Mr. Chair. Commissioner Gonzalez, I'm curious to know, under your interpretation, where 901As would fall.
Commissioner Gonzalez.
So for any violations of 901A that have been found to be in violation, I think that those would be appropriate. But if it is the 901A order that is that issue that was issued earlier this year by the director, if there's a violation of that order, I believe that an NOAV should be issued by staff, and then it should move forward through the enforcement process. And at that point, it could be considered for potentially an additional pattern of violations if that's appropriate at that time. But that's kind of the way I was thinking about that, is that there was an order, there are some allegations of violations of that order, but there hasn't been any adjudication of that or any case being presented by both parties for us to consider.
So that's
just my 2 cents on it.
Yeah, I guess I'm not sure. I'm not sure I actually understood your answer. To me, the 901A has in fact occurred. I think in my mind, what I'm kind of honing in on is it doesn't seem, it doesn't quite seem right for us to consider things that we have not decided. So a future violation that hasn't actually been discussed and we haven't heard both sides be able to do their piece, I agree, should not be included as part of pattern of violations. The 901A, to me, the fact that it actually was implemented by the director and has been, KPK is trying to implement it and has been for many months, and it has not been appealed. To me, I think for me is one of those other factors that can be considered. I'm not sure that any unaddressed violations within the 901A should be considered, and maybe I'm splitting hairs here, but the 901A itself for me would be something that we could consider as a factor in a pattern of violations or a history of what has been done, what the operator has been doing or not doing.
Commissioner Nanjapa?
Thank you, Mr. Chair. I think I tend to agree with the rationale that Commissioner Gonzalez provided overall, but with the additional piece that Commissioner McGowan just added with respect to the order that has been issued. I would also just, agree that the any violations of that order that have not yet been noticed or adjudicated, should not be considered. But the fact that we have an order in place is relevant.
Mr. Chair, I'd like to add something to kind of what my statement was, because I tend to agree with that last point by Commissioner Nanjapa. I think for us to not acknowledge the existence of NOAVs or the existence of an order issued by the director is in my mind a bit silly. I think it's obvious that those exist, and I think that the weight that we put on those when we talk about weight, I think that those have not been adjudicated, and I think that it's important that that those would go through the full process at that point. But the fact they have been ordered, the fact that NOAVs exist, I think to that extent I'm comfortable with acknowledging that those facts. So to whatever qualification that adds to my earlier comments, I'd like to add that as well to these deliberations.
Thank you, Commissioner Gonzalez. Commissioner McGowan?
Thank you, Mr. Chair, and I appreciate Commissioner Nanjapa's ability to say things more succinctly than I am able to. Thank you. I in response to Commissioner Gonzalez, for me, the existence of the 901A and the fact that it's been ordered by the director and it's been in place for several months and has not been appealed is more weight than just it is out there and exists. A series of things had to have happened in order for the 901A to have been ordered. And so while I agree that any violations that might have not been noticed yet or adjudicated yet would not be part of our deliberations, I think the 901A has more weight than just then it exists and we know that it exists. It actually has a plan around it and requirements around it that I think warrant more weight than just it exists, and we should acknowledge that it exists.
Commissioner Messner?
Thank you, Mr. Chair. Thank you, commissioners, for your thoughts on that. I think I tend to agree with Commissioner Gonzalez in this particular situation. I do believe that 525D clearly states that the commission will consider an operator's history of violation of the act or commission rules, orders, or permits, and any other factor. In there, I will note that it says violation of orders, not just orders. It goes on to state that for an operator's history of violations, the commission may only consider violations confirmed by AOC and OFV. To me, this is plain language and does allow for any and all information on the record for any of the confirmed AOCs or OFVs, which are confirmed violations of COGCC rules. I think that this only applies to violations of COGCC rules. I do think that there could be instances that other relevant information may be utilized and reasonable to offer when trying to show a course of performance. These could be adjudicated matters from other state agencies, federal agencies, or the like. But what is clear to me is that no evidence presented should be alleged or unadjudicated, regardless of the source. But I will state that for the history of violations for COGCC rules, I do believe that there is no question that it has to be a confirmed AOC or an OFV. So with that, I would agree with the fact that we can acknowledge that there is 11 outstanding NOAVs, and the 901A certainly exists, but I am not aware that there has been any violation of the 901A order. And so in this commissioner's opinion, I don't believe that that's a admissible piece of evidence in this particular pattern of violations hearing.
Thank you, Commissioner Messner. Commissioner McGowan?
Thank you, Mr. Chair. I guess I'm reading that plain language a little bit differently. I don't know why there would be the clause and other factors if we were just limited to looking at adjudicated violations. And so that second sentence for me does define what the history of violations can consider, and those are adjudicated issues, and other factors, I think, opens the door for us to consider other things. And I agree with Commissioner Messner also that if we're going to be narrow in how we define this, that adjudicated matters from other agencies should also then be allowed as part of that consideration. So, for example, the consent decree that exists between CDPHE and EPA and KPK would be and should be allowed as part of the consideration of a pattern of violations.
Thank you, Commissioner McGowan. Commissioner Messner?
Thank you, Mr. Chair. Just to clarify my interpretation, Commissioner McGowan, is that for me, the other relevant information specific to the COGCC rules is anything involved with the associated confirmed AOCs or OFVs. So other relevant information that's not a permit, order, or violation of the act, including, testimony and pictures and, any evidence put on the record during those AOC or OFV, OFV hearings or the AOC determination, which really don't line itself up with an order, a permit, or a violation of the act or rules. And so to me, that, does, for specific to COGCC rules, that does, my interpretation is that's what that intent was. I do believe, like you indicated, that the other relevant information certainly could be adjudicated violations from other agencies. I think it's clear to me that alleged violations are not permitted.
So, thank you. I'll weigh in a little bit here. I'm in agreement with Commissioner Gonzalez, generally with regard to, for the history of violations, we're limited to adjudicated AOC or confirmed AOCs that we as a commission have confirmed, or OFVs. I do believe there is meaning that should be put into the any other factors relevant to objectively determining whether an operator has engaged in a pattern of violations. I think it does include all of the other matters underneath the OFVs that are adjudicated or the AOCs that are confirmed. But I also think it's more. I don't think it's just limited to that. And I, for one, am of the opinion that a 901A order that the director has issued and that the operator is attempting to comply with is a relevant factor that we should consider. I don't think we should consider it as an as a violation. I think because it's an order saying you need to go do things. Frankly, I think the other way of looking at that is KPK could point out that it's doing a good job of complying with the order. And that would be relevant information as to pattern of violations. So I'm kind of a little bit on both sides on this. I think there are other relevant information that's not going to be found within the file for an NOAV or an OF, whatever, AOC. I mean, for instance, and this doesn't happen in this case, but just as an example, if there was testimony from an operator, and I'm not focusing on this at all, that their, employees said, screw you, we're not ever going to comply with your rules because we don't want to. I think that would be evidence that we should consider. If there's evidence to the contrary, that all of the operators' employees were dearly trying to comply all the time, that would be relevant evidence for us. So I think there is meaning to that, factors relevant to objectively determining, but I think that to read meaning into that last sentence, that when we speak to the history of violations, they need to be adjudicated. So that's where I end up on this piece. Any further discussion? If not, I would make a motion consistent with what I just said. I don't know exactly how we create a motion here to give direction to the parties, but I think it's important to give direction to the parties so that they can prepare their witnesses and get ready for the thing on Monday. I love it when AG Davenport swoops in to save us from our own thoughts.
Well, I hope that means I can talk, Chair.
You can.
Okay, thank you. Commissioners, as the chair just noted, I do think probably the most important thing here is for you to give direction to the parties as to what you will or will not consider next Monday and Tuesday in the substance of the pattern of violations hearing. And I'm happy to be corrected by anyone, including especially Ms. Stafford. But as I see it, there are kind of 4 categories in the pleadings that staff has proposed of evidence or information in support of their pattern of violations allegations. And those are confirmed OFVs or AOCs confirmed by the commission, including the most recent violations that the commission found in last month's hearing. So that's the first category. The second are unadjudicated NOAVs that the commission that have been issued by staff but not yet heard by the commission. The third is the 901A order from the director. And the fourth are spills, which on page 9 to 10 of staff's initial statement, staff noted there are no fewer than 12 spills/releases and noted the spill ID numbers. So I believe that's the world of information that staff is proposing to bring next week to you. And I think what would probably be most helpful is if the commission were to give direction to the parties as to, of those 4 categories of information, which the commission believes it's appropriate to consider as part of pattern violations and which are not.
Excellent summary, AG Davenport.
And I know that Ms. Stafford has just popped up. It appears I might have missed something.
And so we still have a chance to ask questions of either attorney. And so I will ask Ms. Stafford a question. And the question is, did Mr. Davenport correctly summarize the 4 categories of evidence that you're asking us to consider?
Thank you, Mr. Chair. I believe there's one additional category which relates to corrective actions noted in inspections.
Oh, I'm sorry.
But I think otherwise, Mr. Davenport correctly captured our list.
Okay, so we'll add that 5th category as we deliberate. Mr. Jacobs, did you want to weigh in?
I had the same thought, inspection-related corrective actions. Thank you, Ms. Stafford and Mr. Chairman.
I love it when the attorneys are aligned.
And may I chime in just for one more moment? And my apologies to Ms. Stafford and Mr. Jacobs for failing to include that 5th category. I would just like to clarify for everyone that I believe for that 5th category, those are corrective action inspection reports for which there has been no NOAV issued or the commission hasn't reviewed in any way those corrective action inspection reports. Is that accurate?
I believe that's accurate, Mr. Davenport. Any outstanding corrective actions that might be in an NOAV.
Might or might not be in an NOAV, right?
There might be in an NOAV. Yeah, oh, yes, sorry. I agree with Mr.
But either
Jacobs.
way, I'm sorry for interrupting, but either way, the commission hasn't reviewed those. That fifth
Correct.
category, the commission has not reviewed them yet. Okay.
Correct.
Commissioners, does anyone want to tackle a motion? Commissioner Nanjapa, I think I saw your hand first.
Thank you, Mr. Chair. I'm not necessarily jumping to the motion, but I'm not sure if we need to kind of, in determining what the motion is going to say, run through these 5 categories. And so for me, I would say the first category of confirmed OFVs and AOCs, including the most recent OFV deliberations in August 2021, would be included in the scope. I would say the 901A order would be in the scope, including relevant information leading up to issuing the order. I guess I have I would have a question about the spills. I'm trying to recall now, these are also spills where NOAVs have not yet been issued, is that correct?
This effort, it's your evidence or your proposed evidence.
Thank you, Chair. The spills, yes, they from what I can tell, these are spills that have occurred post, so after the issuance of the 901 order.
After the issuance, okay. But so NOAVs have not yet been issued. Is that correct?
To my understanding, yes, that is correct. No NOAV has been issued yet.
Okay, so I guess this is, in my view, we would not consider those, but for the existing confirmed NOAVs the confirmed OFVs or AOCs, any of the relevant information with respect to corrective actions in the inspections that led up to the NOAV, or the AOC and OFV that resulted from those, I think would be relevant. But I would then say that the spills that have not yet sorry, I want to think about the spills one more minute, but I would say the corrective actions in inspections that an NOAV has not yet been issued would not be included. The spills, I am thinking about the ways in which they were reported. And thinking about whether that should be relevant. I'm not quite sure at this very moment where I land, but I will throw that out there for the other commissioners' thoughts. I don't know what happened to Chair Robbins. Could I ask a question? Corrective actions don't necessarily lead to notices of alleged violations, correct? They're a tool for our inspectors to use to take care of something without it escalating to that point. Could someone clarify for me, please?
Commissioner McGowan, unless AAG Davenport wants to jump in, I could answer it for you.
It's the commissioner's pleasure as to who she would like to have answer this question.
Well, AAG Davenport is my attorney, so if he is able to answer, I will ask him to answer it.
Okay, yeah, I think I am able to answer it. The answer is you are correct. A corrective action inspection report does not automatically lead to an NOAV. The staff has the discretion to determine how to resolve a corrective action inspection report that way. and may certainly do so without issuing an NOAV.
So this is something that might never be adjudicated because it gets taken care of at a lower level and the operator simply performs the corrective action. And so for me, I guess these might be considered other factors, or they might be something that turns into an unadjudicated NOAV that we haven't considered yet. And so I'm not quite sure what to do about corrective actions in an inspection.
Commissioner Messner?
Thank you, Mr. Chair. I wonder, AAG Davenport, if you would run through those 5 things for me one more time, just to make sure that I'm clear on them.
Happy to, Commissioner Messner. The first category are the confirmed AOC, commission confirmed AOC or OFE orders. The second category are the unadjudicated NOAVs. The third category is just one matter, the 901A order from the director. The fourth category is the 12 spills and releases identified by staff on pages 9 to 10 of their initial brief. And the fifth category are corrective action inspection reports.
Okay, thank you. That's what I thought it was. So this commissioner's opinion currently, and I appreciate the dialogue because it is helping me evolve some thoughts I have on these things, but some of my thoughts also have stayed the same. You know, I do believe that there's no question that confirmed AOCs or OFBs and all associated information around those is admissible evidence. And so anything on the record associated with any confirmed AOC or OFB is admissible. I do not believe that unadjudicated NOAVs alleged evidence is admissible, so I would say no. I do not believe spills, just spill reports are, to this commissioner, relevant or admissible unless associated with a confirmed AOC or OFB, and then would very much be admissible and relevant to this commissioner. And the same would go with corrective actions associated with any confirmed AOCs or OFBs, I find admissible and relevant. As to the 901A, I don't know how relevant it will be to this commissioner, but I'm completely okay with having it as admissible, as it is important to some of the other commissioners that are here, and they may find it relevant or weight it differently than I. And so I would be fine with the 901A being admissible as well.
Mr. Chair, I can go next.
Sorry, failed to unmute. Commissioner Gonzalez?
Thank you, Mr. Chair. So what it comes down to for me is what we're asked to find in this pattern of violations hearing, and the elements associated with that is a history of noncompliance with the act, rules, orders, or permits, and a pattern that demonstrates the operator's persistent disregard for, inability to comply with legal requirements of the Commission's authority. When I think about that in terms of these kind of 5 aspects of evidence that staff wishes to bring in as part of these hearings, I think for the confirmed orders finding violation, AOCs, that's in, there's no question there for me. For the outstanding NOAVs, for me, those are out. Those are alleged violations. They're not violations yet that have been adjudicated, that should be considered as part of a pattern of violations. For the 901A order, I acknowledge the existence of that order. I understand what it is and what's being ordered there. For me, I think that should be out because there's no alleged violation of that order. For spills and releases associated with KPK, I think those should be out because, again, there's no alleged violation of a rule, order, or permit. For inspection-related corrective actions, I believe those should be out because, again, there's no alleged violation of rule, order, or permit. And in my mind, if there's only an allegation or if there's no allegation, I don't know how I can consider those as being part of a pattern of actual violations that we're thinking about in the cases before us today. So I'm in agreement for the first one, the confirmed OFVs, AOCs. And when it comes to other relevant factors, you know, when we adjudicated the violations that we did a couple weeks ago, and for any that had been adjudicated prior, they had elements for each of those rules to find those violations. Now, along with meeting those elements and along with the evidence and testimony supporting those violations and those elements, there was plenty of evidence that was put on that was part of the record that was given consideration around communications, around interactions with COGCC, timeliness with corrective actions. And I think those are all part of the other relevant factors that could be considered in our pattern of violations hearing that do directly go to actual violations that have been, you know, that KPK has been subjected to. So kind of for those reasons, that's where I stand on the 5 categories of evidence that the staff has asked to bring into this hearing.
Commissioner McGowan?
Thank you, Mr. Chair. And I agree with Commissioner Mesmer that hearing everyone's thoughts has been helpful. I agree with all the commissioners on 1 and 2. Yes to the adjudicated matters that should be included. No to the non-adjudicated NOAVs. I think the 901A and the facts that led up to the 901A being ordered by the director should be included. I'm splitting hairs here, but I don't think that anything that hasn't been complied with under the 901A can be included until it comes to the commission as a violation and gets adjudicated. So I hope that makes sense what I'm asking for or what I think. I'm going to skip spills because I'm not sure about spills. I'm going to split the baby again for corrective actions. Corrective actions for which the operator agreed to and is implementing, I think should be included as another factor. Corrective actions that they haven't done anything about perhaps or disagreed with might turn into an NOAV. And so I don't think they can be included. And I'm not even sure we can split the baby that way. And if we can't, then I'm not sure that we can include the corrective actions because we don't know which of those might turn into a notice of alleged violation, unfortunately. So I'm kind of struggling with that one. And I guess I agree that the spills probably shouldn't be included unless they've been attached to a previous NOAV, adjudicated.
Thank you, Mr. Chair, and yeah, thanks to all my fellow commissioners for the dialogue. I'm still where I was at the beginning, so basically in agreement on the confirmed OFVs and AOCs and any facts and et cetera associated with them. And I do believe that the 901A order and matters leading up to it, and as well as I think Commissioner Robbins was the one who, Chair Robbins mentioned, you know, the progress on that could also be relevant since the order has been issued and since it has not been appealed. And I would not include the spills. That was the piece that I was on the fence about, given that these are matters that have not yet been adjudicated or noticed for violation.
Commissioner Chapa, did you have I can't remember your position on corrective actions.
Same as before, only if they are associated with an existing OFV or AOC, but not any matters that have not yet been included as part of an NOAV, or so, excuse me, as part of an AOC or OFV.
So a limited subset of the corrective actions.
As they pertain to the facts of existing confirmed AOCs or OFVs. Does that make sense?
Yeah.
Yeah. Okay.
All right, so I'm looking at my score sheet, and I'm in agreement with Commissioner Nanjapa, like complete agreement. So I'm looking at a score sheet, then number 1 is in, number 2 is out, number 3 is in, with Bill being the vote out. Number 4, the spills are all out. And number 5, it's only corrective actions associated with AOCs or NOAVs, but I'm putting some words into John Messner's mouth because I'm not sure exactly where he was on that.
Happy to clarify, Mr. Chair. I think I had initially said that I'm okay with any corrective actions associated with confirmed AOCs or OFVs. So no different than what Commissioner Nanjapa had said.
Okay, so that's at least 3 votes there that might bring in Commissioner McGowan's vote. But I don't know that it's necessary, and Commissioner Gonzalez would like to speak.
I was just going to confirm that I agree with Commissioner Messner and Commissioner Nanjapa that, and I think it was pretty consistent what I said about the OFVs and AOCs, that yeah, any corrective action, any reports, any evidence associated with those, I think should be in. So in that limited subset, yes, I agree with that. But that's what I agree with. And also I want to clarify something you said, Chair. Just want to make sure you are considering AOCs and OFVs, not AOCs and NOAVs.
Yes, sorry, I just wrote down the wrong acronym. Okay, any further discussion amongst commissioners? So AAG Davenport, can we just have a motion that's consistent with the chart I just read off, and then we could then perhaps have the hearing officer amend the final pre-hearing order consistent with the motion? Is that workable?
Yeah, I think that's appropriate, Mr. Chair. Thank you. I think I just would, if it's all right with the commissioners, clarify that I think recognizing that it may not be a 5-0 vote, the motion that has been, though not made yet, is discussed is that all confirmed by commission AOCs and OFVs, as well as any underlying facts, are admissible in next week's hearing. The 901A order from the director and underlying facts is admissible. None of the other categories of information, corrective action inspection reports, spills, or unadjudicated NOAVs proposed by staff will be admissible at next week's hearing.
I think that was Commissioner Messner.
Thank you, Mr. Chair. I think it's important to quantify that by saying that if there was spills or corrective actions that were confirmed by an AOC or an OFV, that they would be admissible. Having not gone line by line through Ms. Stafford's evidence, I don't know if they are all unadjudicated or not. So, so I would like to emphasize that if there are spills or corrective actions that are associated with a confirmed AOC or OFV, that it should be admitted.
AG Davenport, do you incorporate
that
into what motion you're creating for us?
My suggested motion language was intended to include the point that Commissioner Messner just made, to the extent any confirmed AOC or OFV and all underlying matters, so that would include a spill report or a corrective action inspection report included in that, would be admissible.
Okay. Okay. Do we have a motion? And I think you can just move to approve the motion outlined by AG Davenport.
Chair, I move to approve the motion outlined by AG Davenport.
Second.
Okay, we have a motion and a second. Do we have any further discussion?
Mr. Chair, yeah, I'll just state again that I was the no vote for the 901A order, and I stand by that. However, you know, just given that we've all kind of considered what each of us has brought to the table, I am going to vote in favor of the motion. But I just wanted to kind of state that thematically and principally that for the 901A order, in general, I do not believe that it should be considered as part of these OFB, as part of these pattern of violations hearings, but for this particular motion, I will be voting in favor of the motion as proposed or as, I guess, drafted by AAG Davenport and as motioned by Commissioner Messner.
All right. Thank you for that clarification, Commissioner Gonzalez. Any further discussion? Commissioner McGowan?
Thank you, Mr. Chair. So in that vein, I'd like to clarify that I'm going to vote yes as well, based on our discussion. But I do believe that some corrective actions could and should be considered other factors. They don't all necessarily lead to NOAVs, and I think they are relevant factors. So I disagree with that piece, but I will be voting yes overall.
Any further discussion? Seeing none, all those in favor of the motion signify by saying aye.
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 Any opposed? Motion carries. We will get the hearing officer to amend the final pre-hearing order so that it is consistent with this motion, and the attorneys are directed to present their case next week consistent with the motion. Thank you both thank all three of you, all four of you, for your continued professionalism preparing before us. And I think with that, we are done with our agendized items for today. With that, I would look for a motion to adjourn.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
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 We are adjourned. Good night. Goodbye.